This is Law Bytes, a podcast with Michael Geist.
Regulating AI systems is something that we believe must be done. However, it seems odd to add these regulations in a bill that has to do with privacy protection and with the analysis, circulation, and exchange of personal information. Artificial intelligence, Mr. Speaker, is its own beast in a way, and it should be studied and treated separately.
It hasn't garnered much attention, but Bill C-27, the government's privacy and artificial intelligence bill, is slowly, very slowly, making its way through the parliamentary process. The bill is currently at second reading in the House of Commons, and though it hasn't been given much time for debate, there is reason to believe that it will eventually be referred to one or more House committees for study. One of the emerging issues has been the mounting opposition to the AI portion of the bill. As you just heard, the NDP recently asked the Speaker of the House to divide the bill for voting purposes, separating the privacy and AI portions. Moreover, several studies have been released which place the spotlight on the concerns with the government's plan for AI regulation, which is widely viewed as vague and ineffective. Christelle Tessono is a tech policy researcher based at Princeton University's Center for Information Technology Policy. She was one of several authors of a joint report on the AI bill, which brought together researchers from the Cybersecure Policy Exchange at Toronto Metropolitan University, McGill University Center for Media, Technology and Democracy, and the Center for Information Technology Policy at Princeton University. Christelle joins me on the podcast to talk about the report and what she thinks needs to change in Bill C-27. Christelle, welcome to the podcast.
Thank you so much for having me.
Yeah, pleasure to welcome you. You know, I've covered AIDA in some past episodes, so there's been a chance to take a look at some of the issues around the so-called proposed Artificial Intelligence and Data Act, part of Bill C-27. But with the government starting to move on the bill, I thought it would be worth revisiting, especially in light of your recent report that you were part of. Before we get into some of the recommendations and some of the analysis that's there, and I think you've done a great job highlighting some significant issues associated with the AI parts of this bill, can you tell me a bit about the origins of the report and who worked on it?
Yeah, so this report was published through the Cybersecure Policy Exchange at the Toronto Metropolitan University, and it was a collaboration between researchers at McGill University, Princeton, and also a researcher at the Mayo Clinic in Boston, more specifically, Ewan Stevens, Momin Malik, Sonia Salom, Supriya Dwivedi, and Sam Andre. It was really born out of a concern about the absence of human rights provisions in the bill, but also a genuine surprise. We did not expect ADA to be part of the bill. Yeah.
No, I don't think you're alone in that regard. I think that part of the legislation has caught a lot of people by surprise. Now, I want to get into the recommendations. The report has 5 major recommendations and kind of walks through each. But before we do that, can you describe a little bit for those who aren't familiar with this part of Bill C-27, what exactly this legislation is all about?
Yeah, so ADA stands for the Artificial Intelligence and Data Act, and it attempts to create a regulatory framework for international and interprovincial trade and commerce in AI systems. It does so by requiring companies to adopt measures to mitigate risks of harms. It also outlines requirements for public reporting of AI systems, and allows the Minister of Industry to order the production of records related to AI systems. And more specifically, and what it has been branded as is the fact that it allows for the prohibition on the use or possession of illegally obtained personal information, and creates really high fines for contraventions to the bill. And it also creates the position of the ADA and of the AI and Data Commissioner.
So it's got a privacy element. It's got elements with respect to how AI might get regulated, or the use of AI systems might get regulated in Canada. So it really it attempts quite clearly to bring Canada into the regulatory space when it comes to artificial intelligence. Now, that said, the inclusion of this within Bill C-27, which for those that have been following will know that that's the large privacy reform bill as well. So the inclusion of AI within what is otherwise seen as a major update to PIPEDA, our private sector privacy legislation, I think caught a lot of people off guard and certainly by surprise. Can you tell me a bit about the consultations, if any, that the government undertook with respect to the bill, and what you recommend in terms of addressing what I think some see as a real shortcoming in terms of that advanced consultation and public participation?
Yeah, it remains very unclear who was consulted for the bill and when those consultations happened. But it is clear, however, that there was no public consultation. My assumption is that ADA may contain pieces of discussions that came up during the national public consultations on the digital charter back in 2018. But I wasn't there, so I cannot speak to whether that is actually what happened. It is also my understanding that the government's AI Advisory Council was also consulted on the legislation. However, there are no publicly accessible records accounting for how these meetings were conducted and the issues that were raised by the members of the council. I think that moving forward, the government should look to hold a public consultation on the bill. I'm afraid that a committee study will not be enough to get it into shape. ISED has recently held a public consultation on the National Quantum Strategy, which consisted of roundtables, online surveys, and publication of the findings from these discussions. I'd be interested in the government taking such a similar approach in documenting each step and having a clear timeline on the publication of a new version of ADA. I think what people want is more accountability when it comes to drafting these things, and being clear as to how conversations will happen, when they will happen, will make things a lot more accountable.
Sure. Yeah, no, I think that's a fair point. It's a bill that at the heart, one of its policy objectives is greater transparency when it comes to AI systems. Yet there's a certain irony that the development of the legislation itself is not particularly transparent. We don't know a lot, and I think the recommendation that, in a sense, that really should be the starting point, as opposed to relying on a committee process that, it seems to me, given the fact that this is twinned with a very large, important piece of legislation on privacy, may well get even lost in the shuffle, really is absolutely essential. Now, should there be either a consultation, or if we get the committee hearings, it seems likely they're going to delve into some of the specifics. And some of the specifics, of course, involve some of the definitional issues, which become really essential when we're thinking about what's included and what isn't. And you note that I think somewhat oddly, for something that's all within the same bill, there is both a privacy and the AI dimension that we've been talking about. There are different definitions for AI and AI systems that exist within the bill. Can you unpack that a little bit for me? And sort of, it seems odd to find that in a single piece of legislation.
Oh yeah, that was very odd when I read it. Basically, what we found is a lack of cohesion for the definitions related to AI systems. In the first part of the bill, the Consumer Privacy Protection Act, the CCPA, uses the term automated decision systems and define it as any technology that assists or replaces human judgment in decision-making contexts through various techniques such as machine learning. However, ADA uses the term artificial intelligence system to refer to autonomous or partially autonomous processing of data that generates content or makes decisions, recommendations, or predictions. In other words, different approaches are ascribed to the same set of technologies. The fact that these definitions are different across both acts could lead to an uneven and unpredictable application of the law. This is a very significant problem because the very same systems may be used in ways that infringe rights under CCPA and ADA. these different definitions of AI could very well mean that a person has recourse under only one part of the law due to these, inconsistent definitions.
Yeah, no, it's certainly odd. It's not that you don't necessarily or can't find instances where different pieces of legislation may have slightly different definitions for certain issues, but within the same bill really makes it feel like you've got two separate pieces of legislation kind of crunched into one within C27. Speaking of definitions, you also argue in the report that the definitions need to be technologically neutral and future-proof. Can you explain a little bit what you have in mind?
Yeah, so by technologically neutral, we mean that legislation should look to address the source of concern around the technology instead of naming specific techniques or technologies, because you can achieve the same outcome by applying a different technique. Technology, as we know, evolves rapidly fast. So being specific as to the technology itself might not be the best way to go about it. And by future proof, we are referring to issues around AI that are not born out of AI itself, but rather that are exacerbated by AI. Think of, for example, sexism or racism. In other words, the concern regarding definitions should not be whether things are labeled AI or machine learning, deep learning, whatever, or they employ one of the named techniques that are associated with AI or ML. To be future-proof, technology neutral, and to address the core issues of concern, the federal government should consider working with technologists to define algorithmic systems based on their broad applications instead of focusing on their techniques. I think these types of definitions make it easier to not disconnect artificial intelligence and innovation from the realities of systemic discrimination in the country.
Yeah, no, and it's that the concerns around systemic discrimination, the potential for bias that, of course, I think has captured the lion's share of attention when it comes to concerns associated with AI. And as you mentioned, the need for inclusion of a human rights perspective is in many ways what drew many of the researchers behind this report to develop the report. And it concludes that the bill does indeed fail to address human rights implications of AI. Can you provide some examples of how that might be the case? And what do you think we should be doing to better incorporate a human rights perspective into AI legislation?
Yeah, so as currently drafted, ADA fails to address human rights because it only outlines a prohibition on the use of systems that produce harm, defined as physical or psychological property damage or economic loss. It also introduces the term bias output. So if an AI system produces output that can be interpreted as discriminatory based on Section 3 of the Canadian Human Rights, then it is illegal. And then it also provides prohibition on systems that are used with illegally obtained personal information. That is very broad, and it's not very specific as to which types of human rights should be protected. A relevant example is the use of crime prediction software by law enforcement agencies and public safety actors in the country. AI systems can enable the rapid collection of large amounts of information, which can increase the speed at which people are detained and arrested, unfortunately. The possibility of arbitrary and discriminatory decisions may occur more quickly and at higher rates than when the technology is not used. In this case, freedom of expression, equality rights, or freedom from discrimination, the right to life, liberty, and security of the person, freedom from unreasonable search and seizure. I mean, I could go on. They're all just unfortunately implicated by these technologies. And that's why we argue in our report that what is needed is an approach to regulation of algorithmic systems that both identifies the technology's human rights risks and provides obligations and rights to properly address those critical risks.
Yeah, I mean, when you highlight so many different implications, I mean, it really does touch on potentially AI touches on so many different issues. It really begs the question in some ways, should there be certain AI uses that are simply off limits? You know, it's one thing to say that we want to ensure that there's a human rights lens to regulation, and but that still presupposes in some ways that, well, some of these systems will be permitted so long as we go through some sort of analysis. Do you think that there are certain things that we should simply say, sorry, we're just not going to permit that within the country, given the risks involved?
Oh yeah, definitely. What's been quite popular right now is the use of biometric or health-related bodily information in artificial intelligence systems. More specifically, let's think about emotional recognition or facial recognition technology used by law enforcement. Experts note that these systems tend to analyze and categorize people on the basis of biometric or health-related bodily information, which can be seen as an extension of physiognomy. And for context, physiognomy is like a discredited junk science that examines biological and facial features to ascribe a propensity for certain behavior. A notable example of this is how some products and studies have like attempted to use facial images to build models that could identify people who are more susceptible to criminal behavior. The use of biometric recognition and categorization systems can further facilitate systemic discrimination and historical inequities. We know that there's an overrepresentation of Indigenous, Black, and Black people in the Canadian carceral system. If we build systems with feeding them images of Black and brown people, Black, Indigenous, brown people, like the system will learn that, you know, if you're Black or Indigenous, then you're more likely to be a criminal, which absolutely makes no sense.
Yeah, no, that's, I mean, that's I think the kind of one of the paradigm examples we see around some of the concerns with AI. Beyond some of the standards that are established within the bill, there's questions about the applicability of the bill. Clearly, it's going to apply to the private sector. Who else, if anyone, does it apply to? Does it apply, for example, to government, which of course talked about, say, law enforcement using this? To what extent is government captured by this legislation, if at all?
Oh, yeah. So ADA explicitly excludes federal departments, such as, you know, the Canadian Revenue Agency. It also excludes Crown corporations, the Department of National Defense, Canadian Security Intelligence Services, and then the Communication Security Establishment. This is a problem because there are very well-known human rights risks associated with state-deployed AI systems. We don't need to look too far. For example, the RSCMP's use of facial recognition technologies through Clearview AI is a pretty good example of the dangers that come with AI systems being used by government. Given that Bill C-27 broadly addresses the modernization of private sector privacy laws on a superficial level, it makes sense that ADA was not drafted to include federal government. However, there's no legal or constitutional reason for ADA to exempt federal government institutions, given their potential to pose serious harms to individuals. And although we have the directive on automated decision-making that applies to certain federal government institutions, it still contains numerous gaps and fails to provide individuals with recourse. As a result, it's not currently equipped to address the public safety and human rights risks related to technology. What we need is a greater cohesion between private sector and public sector regulation. And that's why we want ADA to be applicable to government institutions.
Okay, no, I don't, and I think there are many who would agree that government, if anything, should be leading by example on some of these issues. And while they have developed some internal review systems around AI, similar to privacy impact assessments, AI impact assessments, regulations still are few and far between. Lastly, in terms of some of the major issues that come out of the report and out of this legislation is basically the question of how all of this is going to function. You know, what's the administrative or government structure that's envisioned? Do you think that it's an effective one based on what the government has in mind? Is there effective independent oversight of the system? What, if anything, do you think could be improved based on what the government's outlined in the bill?
Yeah. So when I read the legislation, it felt like the governance structure and vision for this bill relies heavily on self-administered audits and a concentration of power in the hands of the Minister of Innovation. To be more specific, let me explain how power is concentrated, and then I'll talk about the audits. So the ADA establishes the creation of the AI and Data Commissioner, and also the potential for the creation of an advisory committee. As currently drafted, ADA creates the position of the commissioner, and they'll be tasked with assisting the Minister of Innovation in the administration and enforcement of the act. However, the commissioner is named by the minister and is not afforded the powers to enforce ADA independently from the minister. The advisory committee, I have so many issues with it. First, the terms of reference are not included in the law, so it makes it quite unclear how many times the committee will meet, or if they're tasked with writing reports, or who will be able to be part of it. And more significantly, this advisory committee does not have enforcement powers or capacity. They're here just to consult, like the existing AI Advisory Council. Now, onto the audit mechanism that the bill establishes. ADA provides the minister with the ability to require that an audit be conducted if there are reasonable grounds to believe that contraventions to certain sections of the law have occurred. The audit can be done internally by the company or by hiring services of an independent auditor. As a result, oversight of algorithmic systems in this legislation is primarily administered by the companies themselves through the forms of audits. This is concerning because research has demonstrated that the quality of audits is very poor when the auditee selects and compensates the auditor. What I've learned in my research is that regulating AI systems requires multidisciplinary collaboration. We need to build the adequate infrastructure for this by hiring experts across fields and giving them independence from the minister. What I envision in terms of independent oversight is the creation of an independent body empowered to investigate contraventions, enforce law, craft regulation, develop standards for audits and AI system design, and have also the ability to restrict, withdraw, and recall AI systems that do not comply with the law. More concretely, this could look like providing more powers to the Office of the Privacy Commissioner. So instead of having like an ombudsman role, they actually can be more of enforcers of law. Or even we could create an independent tribunal that administers and enforces ADA, for example. I know that Bill C-27 has provisions to create a tribunal for the CCPA. So maybe we could have a tribunal that covers both. I'm really open to any suggestions as long as they are anchored in independent oversight. Yeah.
Yeah, no, I mean, and you've highlighted a whole series of different potential governance models, and I think you're right to emphasize how essential it is that's an independent expert oversight, and certainly specific tribunal or perhaps the Privacy Commissioner's office are certainly a couple of possibilities. So, you've offered up as part of this report a wide range of recommendations. Why don't we close with this? What do you think needs to happen next? There've been calls, for example, to separate the bill. Let's sort of move ahead with privacy, perhaps pump the brakes a little bit on the AI side, engage in some of the consultation that you've just described. What do you think? What should the government's next steps be with respect to this aspect of Bill C-27?
I think that we need a proper public consultation on ADA. I do not mind ADA being cut out of Bill C-27, but what I do mind is efforts to regulate AI to die off at committee stage. At the time of this recording, Bill C-27 is being debated at second reading in the House of Commons, and I hope that when it reaches committee, members of Parliament are able to get a commitment from ISED and the Minister of Innovation that they will launch a public consultation on the bill, that the committee should, I also believe that the committee should look to outline some parameters, such as, a timeline, the types of communities that should be involved in this public consultation, and a timeline. We need this legislation. We needed that yesterday, I think. because of the urgency of the issues that arise with AI systems. We're in a minority government. I think that members of parliament can afford to be a bit bold in their demands, and we shouldn't let ADA just die off because it's bad. I think we can work to make it better.
Okay, well, we are in a minority government situation, although we haven't necessarily seen that much, let's say, legislative innovation out of committees, but there's hope, and you're right, certainly, to highlight this as an area that has enormous implications really across the board for society. So it's so critical to get it right. Christelle, thanks so much for joining me on the podcast.
Thank you so much for having me, Michael.
That's the Law Bytes podcast for this week. If you have comments, suggestions, or other feedback, write to lawbytes@pobox.com. Follow the podcast on Twitter @LawBytesPod or Michael Geist @mgeist. You can download the latest episodes from my website at michaelgeist.ca or subscribe via RSS at Apple Podcast, Google, or Spotify. The Law Bytes podcast is produced by Gerardo Lebron Laboy. Music by the Laboy brothers, Gerardo and Jose Lebron Laboy. Credit information for the clips featured in this podcast can be found in the show notes for this episode at michaelgeist.ca. I'm Michael Geist. Thanks for listening, and see you next time.